to understand this step by step and also know if we have a chance or our chances are out of the door. His name is Clifton Ouko, advocate of the High Court, and also an associate with Rodel. You'd have to guide me on that. Pick me up because the phonetics on that really work my tongue.
You've said it correctly.
Yes. That's wonderful.
Yes.
So what happens in this situation?
Thank you so much for having me tonight. So as you said, my name is Clifton Ouko. I do dispute resolutions at Rodel. Yes, this is an interesting position or situation that we get ourselves into. And I think there's something that we call private international law. So private international law is a law that governs relations between one person to the other. I think you've had public international law. That one governs relationship between states, between Kenya and Uganda. But now, when you talk about private international law, we're talking about a situation where there is a transaction or there is a dispute which has a foreign element. And the foreign element in this case could be somebody from another country. It could be that the contract is supposed to be effected in another country. It could be that a child was born in another country. It could be that you're doing inheritance and you are inheriting a property that somebody bought that is in Zambia. So it is very many things. It isn't just really constricted to a business transaction. So in those situations where there is a foreign element, then we have to address our minds to how do we proceed with having this dispute dealt with before the court. You could be having a good case, but if you don't know how to go about it, you might have your case thrown out. So the first thing is we have to answer the question, which country has jurisdiction? That's the first question. The second question is, what is the governing law? The third question is, once I have my judgment, how do I come to have it recognized in either Kenya or another country? And thereafter, how do I have it enforced? Because having a judgment is one thing. Enforcing it is a separate thing.
Clifton, before we go so far,
yes,
you've actually tickled my memory in bringing matters of inheritance, because I think that's the last topic we engaged with you. And currently we are seeing, if it is a matter of possible disputes, people are engaging with partners from across the borders, which means this becomes a relevant item to look at. And I want us now to, like, when someone is listening to what we are conversing about, they're hearing that there is a country that has jurisdiction, there is governing law, and all of a sudden they need a pen, they need the AI to get there. I want us to break it, gliding slowly and slowly.
Okay.
When you talk about the legal disputes crossing the borders, what is happening there?
Okay, I think I've explained, but just to be particular. So I'll start with the one for inheritance. So person A's father has passed on, and they want to undertake a succession. The person did not leave a will behind, and you want to put together all the assets of the deceased person, take it before a succession court, and then complete the succession, then transfer the property to yourself. So you'll have to check. So where are these properties? Are they immovable property? Are they immovable properties? So if they are immovable properties include land, or like this building is an immovable property. So if this land is situated in Uganda, then the successions surrounding that particular land will be governed by the law of Uganda. So that's the first. So I've run to issue 2, governing law. Which court has jurisdiction? We now have to also do an assessment on that question with regards to this inheritance dispute.
Since you're still there,
yes,
we can be able to say that the law of the land is what is followed.
Yes.
Is that like, can we seal that there?
No. It is not ideal for all cases. It's only for this example I have given you.
Okay, let's look at the example then.
Yes. So let me give you another example. So person A is marrying person B. Person A is Australian. Person B is Kenyan. So how do we establish that these persons, for instance, are able to get into a marriage? What are the qualifications for getting into a marriage? You must be 18 years and above. But then different countries also have different requirements. So for you to determine which law will govern that marriage, every person will be governed by the law from where they come from. Then assume we want to go and divorce. Thereafter, which law will apply? Because remember, at the point of marriage, you apply the law of Kenya to assess whether I'm suitable, and the law of Australia. Then at the point of divorce, which law do we apply? We'll apply now at that instance the law of the place where we went to stay. So if the person from Australia came to stay in Kenya with me, and then there's also the place of celebration. You get, so there's a place of celebration also could have been the UK. So you either go and divorce in UK, but if we left UK and went to stay somewhere else, you apply that law that way sequentially. But now, just to be able to also guide our viewers meticulously. So on the first issue which you have to determine is which court do you go to, which country court do you go to. For a business transaction, the first question you ask yourself is, what does your contract say? So in the contract, if you've seen a commercial contract, there's a place where they always write governing law. There's a place where they have written jurisdictional clause, or there's a place where they have written dispute resolution framework, where we have either arbitration, or they tell you which court of which country you can go to. So if in case it's a business transaction and you have a contract which has said that the jurisdiction of, for example, of UK will apply, then the first question of jurisdiction is that you have to go to the UK. The second issue, if it's a tort, what's a tort? Tort is a civil wrong. Or for instance, I'm walking out the road here and some vehicle has hit me. So that is negligence in sort. So I want to claim for damages for being hit on the road by a vehicle. And I was in Kenya, but I am Ugandan. So do I sue from where I come from in Uganda, or do I sue here in Kenya? So the courts of Kenya are the ones who will have jurisdiction, the place where the accident or where the event occurred. You get, and then there's the other instance where these are not well specified. So for marriages, remember, it's a place of celebration. But now there are other instances, like for example, inheritance, child maintenance. Now those ones you apply the place where I ordinarily stay. If I ordinarily stay in Tanzania, you go to the courts in Tanzania. If I ordinarily stay in Kenya, you go to the courts in Kenya. But then, when the courts are applying, we are saying the court of Kenya has jurisdiction. It doesn't necessarily apply the law of Kenya. So that's the next question. So what law will be applicable? So again, we go back to our contract. If in case it's a business transaction. So a business transaction, our governing law says that the laws of the English law will apply. But remember, the jurisdiction clause said the courts of Kenya. So a judge sitting in Kenya will hear the dispute. But this judge cannot apply the laws of Kenya. He will apply the laws of England. Yes. And more often than not, when we do transactions online, digital transactions, we are ordering things from abroad. We are ordering cars from Japan. We are ordering, I don't know what you could order, an iPhone from... Interesting things can be ordered. And then we always send those policies and whatever documents. We don't read them. You get? So, I mean, your iPhone doesn't come.
But, Clifton, let's just be frank.
Yeah.
I'm talking as a common person. Even when you look at the apps that we subscribe to, you go through the first page, the second page, the third page, the fourth page, and what you want to see is where do I just finish this business? Where do I sign? Perhaps you can be able to get us, because what is the risk of that? Because it's a lot of pages, and for some reason, maybe you can even tell us what's up with you legal guys in making this fine print, very tiny words, but very many, that they discourage anyone from even beginning to read.
The next time you get any of such, just call me and pay the fees.
Aha. Nice way to play business.
So that I can read it for you. Because essentially, those are the pitfalls. You get the pitfall. The first pitfall for a customer or somebody's business is you don't read the document that is given to you. The moment you don't read it, you don't know, and then you end up going to you end up going to the court in Kenya, and then the other party comes with a preliminary objection, and they tell the court, "Look, you have no jurisdiction to hear this case." Reason. Look at the contract that we signed with this person. Remember, this contract, you didn't read it. The contract says that you have to appear before an arbitrator. So then you're supposed to declare a dispute. So in cases where there's an arbitration clause, what you're required to do is you're supposed to declare a dispute. So once you declare the dispute, then you either the two of you agree on an arbitrator, or you write to the Chartered Institute of Arbitration here in Nairobi to appoint for you an arbitrator who does a private sort of court process.
And before we even go into the arbitration situation, maybe you can be the one who gives us one sound direction. When we are having this breakdown, and you look at those clauses, particularly in contracts, the ones that are extended in nature, I may read, but I might not necessarily comprehend. But I have read. Is there a place for defense in case I read and I did not understand, but I actually read. I went through this,
and then you signed.
And then I looked and yes, now this is something I think.
And then you signed. What our courts have said up to the Supreme Court, the contracts are for the parties. Once they sign it, it is binding upon them. The only instance that a court can be able to come and say that this contract will not be enforced is where the contract is unconscionable, where the terms, there's a weaker party in that contract who has been forced to enter into the contract with certain terms which are beyond the human comprehension. For instance,
which is where I'm coming at, because I'm imagining I am a normal consumer. I want to be part of or subscribe to this particular thing, and I look at it. And on, let's say, native language, I'm seeing everything makes sense. But there are some things I'm not seeing. Is the law looking at me as someone who was like...
the law will not. And that's why we are here as lawyers.
Okay.
Yeah, the law will not. So in the moment you know that you're getting into an important transaction and you're not able to comprehend what's in that particular transaction, the best thing you can do is to engage a lawyer to review for you the contract and to advise you. So there are very many lawyers outside here.
Let's open it up, because you're going to open this up. Look on matters of digital loans. Let's go into that space. Because for one reason or another, if I'm to look at the statistics, roughly 155 billion has been disbursed through this channel for the last 4 years or so, according to the CBK. And for some, they've ended up in a situation which actually has called the central bank to move into action on matters of predatory loans. Because one, I need the loan. So I'm walking to you because, yes, Wakili, let's talk about even legal services. When I'm there at home, I want money. And I've seen this app. I was actually looking on a video somewhere and an ad came on and they told me, we have this for you. And I'm like, I need this. But in the motion, I've been baited into this place. And we've seen motion of actually cutting away those loans that were submitted to the CRB. That has actually happened. So on a general perspective, when you see such action, and also rallying back to the fact that I may have entered into this agreement, it is a contract. I was of age. I knew what I was doing, but someone was doing more than I knew they were doing to me at this moment. How does that play out now? Well,
I'll simply say that you need to read the terms. Second thing is CBK has guidelines on digital lending. There are digital lenders who have been given license to be able to operate. There's a gazettement to that effect. So the other thing is you need to also check whether the person who you're borrowing a loan from is licensed to do so by the Central Bank of Kenya. There's an interesting case which our firm has written on Rabobank versus, I think there's a businessman in Nairobi. This entity is a Dutch company. So they lent this person a lot of money in dollars, and the person failed to pay the money back. So what happened in that instance is that this entity went before the High Court to claim their money back. But because remember they don't do business in Nairobi and in Kenya, and they are not registered in Kenya, the Kenyan businessman filed a preliminary objection saying this company is not registered in Kenya, therefore they cannot file a suit in Kenya. The High Court agreed with them and said, look, you cannot come from wherever it is you're coming from, and then you want to claim for a loan which you get somebody in Kenya without being registered as a foreign company in Kenya under the Companies Act. So the High Court dismissed the case. But the entity was like, you know what, we are not giving up on this. So they went to the Court of Appeal. And recently the Court of Appeal issued a judgment and disagreed with the High Court. So there are in instances where you consciously enter into an agreement. Of course, you know that the party you enter into an agreement with potentially is not supposed to be entering such an agreement with you. But because you're aware of it and you benefited from that transaction, you'll have to repay the money. What the courts can simply do is they may remove the elements which are unconscionable. For instance, one of the hugest things which is usually unconscionable is usually the interest rates. So CBK has given guidelines on interest rate. We are applying the in duplam rule, where you can't be requested or you can't be required to pay more than double what you have borrowed. So once you apply the in duplam rule, and then you've applied the CBK guidelines and the interest rates which have been able to be set by them, then you can be able to know whether the interest that the person has given you is way above range, and you can be able to challenge that, but you still have to pay the loan back. Yeah.
So just to get it right, in case I went and got a loan from a firm or a bank that is not in Kenya, not registered or recognized by the central bank in matters of authority, they can still find a way of reaching to me, and I will have to pay that loan.
Yes, you will have to. And I think there's a recent case all of us have heard about, the EADB Bank versus Tuju. It has been all over social media. And remember, this entity sits in Uganda. It doesn't sit in Kenya. So all of us know they entered into a contract for a loan agreement. The loan was given out to Honorable Tuju. He was supposed to make the payment to this entity in certain installments, which he didn't do. And the contract that they had entered into had a jurisdictional clause that the matter had to be undertaken through arbitration, and then the laws of England were applicable. So the arbitrator who was appointed in that case, it was an arbitral tribunal who was appointed in that case, they had that claim, and then they applied the laws of England, and then the seat of arbitration was also in the UK. So they issued a determination that he was supposed to repay the whole of that amount of money plus interest. So what EADBK did is they simply came with the arbitral award. So the judgment of the arbitrator is called an arbitral award. They came with an arbitral award, and that takes us to the fourth issue, on issue of recognition and enforcement. And here we apply, there's an act we call the Foreign Judgment Enforcement Proceedings Act, which now tells us how judgments from other jurisdictions can be enforced. And also we also apply the New York arbitral something, which speaks about basically on how to enforce arbitral awards, which Kenya is a partner state to. So what usually happens, you come with a judgment from wherever it is you've come with, you go before the High Court, you file an application for registration. So you register it before the High Court. The High Court will be able to look at that judgment in details to determine whether it can be
enforceable.
Yes. The first thing it will do is there's something which we call reciprocity. So there are 8 countries who we have a reciprocal arrangements with, that any judgment that comes from those countries can be enforced here in Kenya. I think this is just because there are 8 I can mention. There's Tanzania, there's Uganda, there's Rwanda, there's Malawi, Zambia, Seychelles, Australia, and the UK. So any person who has any judgment from those countries against an individual in Kenya, you come with, it will be registered, and then now you can enforce. But now if you're not from those 8 countries, if it's an arbitral award, you apply the New York Convention on Arbitral Awards Enforcement. And if it is just another normal judgment, then you follow the common law principle. Yes.
You've expanded this out and called for judgment.
Yeah.
If I'm to just dive onto the 8 countries that we have a reciprocity arrangement with, does that mean any kind of judgment? Or is it just those that are pertain to commercial matters?
Well, I'll be particular. There are instances, there are particular judgments that will. So what the High Court will do, it will assess. So one of the most easy sell out, not really sell out, easy sell in decisions that you can be able to enforce easily are monetary awards. So assuming a Ugandan court awarded you 5 million Kenyan shillings for being knocked down by a tuk-tuk in Kampala. So you want to enforce this judgment. And then the entity that is enforcing against is here in Nairobi. So you come and file it, you register it, and then you enforce. So what are the ways of enforcement? Here is where you can we call them execution proceedings. Execution proceedings.
So I'm going to come back with that, particularly because you've noted it's 5 million Kenyan shillings, not Ugandan shillings. Interesting bit. But we are breaking it down, one, in understanding when the dispute crosses the border, what are we to do? This is Law Matters, your legal aid clinic showcasing live on TV. We take our first break, but of course we'll welcome you to be part of the conversation as we break it down with Wakili Clifton Ouko.
Ninakukaribisha rasmi kwenye mitindo ya kipwani, kipindi kinachokuza utamaduni wa kipwani, nikikuletea mazungumzo ya moja kwa moja na wataalamu, vyakula vilivyopikwa na kukorombezwa, viungo mwake vya kipwani, ngoma zetu za asilia za Kimijikenda, bila kusahau tarabu na chakacha. Yaani wanawake Uswahilini watakuwa wakinengua na kuzungusha viuno kama panga boy za trekta ndani ya mitindo ya kipwani KUTV, ukiletewa moja kwa moja kutoka Salama Bling Beach Resort kila Jumamosi saa 10 jioni na Jumapili saa 4 usiku, ukiwa nami mtamu wako zaidi ya asali. Mimi naitwa Waridi Tamu. Mpenzi mtazamaji, usipitwe na matamu.
Law Matters, that is the show on your TV, on KUTV, that we are going through. And particularly here is where we break the legal jargon into manageable pieces. And today we are looking at, one, the fact that most of our business is moving on a digital aspect, which means the world is becoming smaller. But in the smallness means more community, but also more disputes, probably. And we want to understand how can we be able to, one, resolve them in a way that is able to be, one, beneficial, and that justice is not denied for any party in any engagement that they're in. And particularly today, we are honored to have the presence of Advocate of the High Court, Clifton Ouko, who is driving it step by step. And before we took our break, we were looking on matters of enforcement. And I'm curious, Wakili. I have filed my case. The law of the land was in the UK. And I've done everything. And now they've given me a win. The gavel is down. It means I have won the case.
Yeah.
How do I get the money that I had gone for? I'm imagining it's a commercial case. And this guy had not paid me. So they have been told to pay me. Okay, now they've been told, I have won the case. Who ensures I get paid?
Okay. It is you who has to ensure that you get paid.
My goodness. Now, then why move to this process in the first case?
Yeah, so as I've mentioned earlier, so we had reached a place where we are saying now you have come with the judgment, you have filed it before the High Court for purposes of registration, for it now to be recognized. So the High Court in Kenya has to recognize that judgment. They'll be able to give you a document that is sealed that the judgment now is recognized as a judgment of the Court of Kenya. You get? So when you come with it from Uganda or from whichever, it has to be recognized in Kenya as a judgment of Kenya. So once that happens, then you proceed now to the process of enforcement. So how do you enforce? So there are very many ways of enforcing. Yes, enforcement now here, I was talking about execution proceedings.
And not among the 8 countries. Now let's expand it wider.
Yes. Execution proceedings. So, I mean, we already identified that this transaction had a foreign element. So I am coming from whichever country and I have a judgment against a Kenyan. I have filed for recognition. They have recognized. I want to enforce. So what do I do? So the first thing is you can be able to check if the person has assets. So here you can be able to use asset tracing agencies to be able to help you if in case you don't know.
And here the burden is on me.
Yeah, it's purely on you. Well, you can engage counsel because now, of course, lawyers we start to have different professional engagements and relationships that we can be able to labor on to be able to get you the services. So, if a person has a bank account in Nairobi, so what you do, there's what we call a garnishee application. You attach that bank account. The bank will be summoned to court to find out whether there is money in that account, and if there is any money, the court will direct them to transfer that money to you directly, without the necessity of the person putting in their documentations and approving or giving the PIN or whatever. So that is one. The other is if the person is having immovable property, you can be able to send auctioneers. If the person has a vehicle, you can send auctioneers. If you see an auctioneer, if you've seen an auctioneer next to your house, just know that kimeumana. If in case we have looked for all assets, we are not finding. We have searched bank accounts we can't get. We have searched for vehicles you don't have. We have come to your home, you have nothing. Or we have been able to do a quantification of whatever it is that you have and it can't satisfy the debt. We can put you to civil jail. We just request for notice to show cause to be issued why you should not be placed into civil jail until you pay the money. So in that instant, they usually do that just as a last resort. So ordinarily what happens, what I've seen happen is that your community might be forced to do those WhatsApp Arambe so that they can raise money to remove you from the civil jail. So those are the ways that you can be able to undertake execution. So it's very much important that when you come with a judgment from a jurisdiction outside Kenya, that judgment is legitimate. So the court will have to verify the legitimacy of that particular judgment and to verify that that judgment actually exists. Then they need to be able to be satisfied that judgment is a mandatory decree, because there are certain judgments that cannot be enforced in Kenya. For example, if you have come with a judgment that requires somebody to vacate a home in Kenya, it is impossible. Because remember, I had told you earlier that where we are having property dispute and the property is in Kenya, only the laws of Kenya can deal with that dispute. You can't take that dispute before a court in another country. Yeah. If you've come with warrants of arrest and you want the person to be arrested to be taken to another country, what is the process? You can't just come and say, I want so and so arrested. If in case there's a criminal offense, then you have to be able to work with the criminal agencies and the Attorney General and follow the procedures which have been placed under the Constitution for that purpose. But you can't come with a judgment and ask the High Court to enforce an arrest.
That's interesting, because now I want us to extrapolate this wider. When you talk this way, it's like we're talking about individuals.
Yes.
Let's expand it wider. I'm dealing with a corporate. But maybe it's one corporate which one has assets in interesting parts of the world. Where maybe getting recourse in matters of justice is troubled. I'm imagining maybe it's company that, one, has a name in Kenya, but assets in Switzerland, some in Albania, and I am out to get what is mine. I have gotten the courts have actually aligned with what is supposed to happen. I have the task of assessing their assets. I've assessed, but the places where they are at is places where it's troublesome to be able to get recourse. What happens to me? Should I surrender, or what happens now?
That's an interesting question. So basically, we are saying you have a judgment from Kenya, and you want to execute it, for example, in Switzerland. So the first question you have to ask yourself is, so there's no reciprocity. That's the first question. So it means the courts in Switzerland will not easily recognize. So then what you do is you apply the common law principles, or we also do an analysis of the laws of Switzerland. What does the law of Switzerland says on foreign judgments? How do they deal with them? So each and every country, you'll realize that they have codified their own local laws on how to enforce foreign judgments. So when such a situation comes, so what you simply do is you give instructions to cancel. In fact, my company is the best you can be able to engage, because Rodl has offices all over the world, including in Switzerland. That's so what we simply do is we'll just engage our Swiss counterparts. We ask them if they can be able to really take us through how to recognize a judgment and enforce it in Switzerland, and then we guide you through that particular process. Yeah, but then for the countries that has reciprocal arrangement, and then the countries that are within the common law. The common law, remember, largely the Commonwealth countries. Then it is very easy for you now to follow the common law principles on enforcement, which basically is what I have told you. The court will ask you to bring all the documentation, including the judgment. They analyze whether that judgment is coming from a competent court of jurisdiction. It's a monetary award. It has not been obtained by fraud. And then it shall be able to issue a determination whether it shall recognize it or not. Yeah.
Now, Clifton, we live in a situation when digital jobs are becoming the in thing.
Yeah.
We had even the government of the day telling us, let's go and make that bob online.
Yeah.
And it means we are doing a lot of remote work, for nations that are across borders.
Yeah.
This is something that probably would be touching the younger generation.
Yeah.
I have worked for these people. I have done the task they needed. Maybe they even gave me some months for probation.
Yeah.
And I was there. And everything I've done, according to me, I've delivered.
Yeah.
And it comes to the matters of compensation. And for some reason, they want to dodge my request for compensation.
Yeah.
One, this company is not anywhere I can be able even to put my hands on. I have found them online. I have done some coding for them.
Yeah.
I have done some arrangement of maybe graphics that would be able to help them.
Yeah.
Or maybe even I've been able to arrange how the hedge fund can go and be profitable.
Yeah.
But they've decided they are going to sidestep me.
Okay.
And I'm here. And I have come to you,
Yeah.
Wakili. I have actually come with some few coins I have, and I expect you to help me.
Yeah.
How do you help me out of that one?
Okay, thank you. That's a very interesting question, and very, very relatable question to most of my peers. Yeah. So the first thing in that scenario is we ask ourselves, which court will have jurisdiction? So this is an employment dispute. So the Employment Act in Kenya is supreme. So if I am working in Kenya, regardless of whether I am working remotely or not, the court that will have jurisdiction to deal with that employment claim is a Kenyan court. The governing law is the Employment Act. And remember that our courts have said that for employment contracts, there can never be an arbitration about an employment contract. So even employment contracts where you have been issued with and they indicate that the jurisdictional issue is going to be an arbitration, that provision of the contract has been declared unconstitutional by our courts. So all employment disputes have to go to the employment court. So what you will do generally is you'll file a claim in court. And then remember, you'll also be required to serve them. And remember, you're serving people who are outside jurisdiction.
How do we do that successfully?
Yes. So the Employment and Labor Relations Court rules has its own rules on service. It allows service of court documents via email. But now the trouble will start in when they don't respond. So what you will potentially have to do, you'll have to seek the leave of court to serve outside jurisdiction. And that means you'll have to serve through diplomatic channels. That's the tricky bit of it. So once you serve them through diplomatic channels and then they don't enter appearance in the case, you can proceed with the case. Or even if they come to defend the case, you can proceed with the case for hearing. Once the court has issued its determination. By the fact that you are working for this entity, I am very positive that you should be aware which jurisdiction they are in.
And before you go very far, you've talked about diplomatic avenues.
Yes.
What do you mean by that?
Oh, very well. Apologies. I may take it lightly that I understand it. Probably somebody's not understanding it out there. Yes. So when we talk about diplomatic channels, so what we say is that you serve them through the Ministry of Foreign Affairs, who will effect it through the Embassy of Kenya in that country.
Okay.
Yes.
That is up to speed.
Yes. So if the entity is in the UK, you simply get the leave of the High Court to serve outside jurisdiction. Then you'll have to be able to do Ministry of Foreign Affairs. They're supposed to take it to the Embassy of Kenya in that country. The Embassy of Kenya in that country now will be able to effect the service to you in that country. Yeah.
We talk also about matters of, I think, the little law I know. They say justice delayed is justice denied. I don't know if it still stands.
I don't agree with it. I don't agree with that.
There was a maxim I had somewhere when I was.
But it depends. It depends on when you say justice delayed is justice denied, because there are instances where if you feel justice is going to be delayed, like for instance, if the Kanjo have come, the county government officials have come and they want to bring your building down because they're saying you're built on the road. If justice is not served, then that is justice denied. So the recourse you have is you can be able to file a certificate of urgency. You can file today, and tomorrow morning you have orders restricting them from. So if that then delays, then I will say denied. But then there are instances where the court processes takes too long. We think takes too long. Well, it takes too long at times out of design, but of course at times out of our action as parties who are in cases. Like for instance, if you have taken someone from court to serve a foreign company, and then you take too long to go to the Ministry of Foreign Affairs, you delay to take it to the relevant, you delay to seek for leave to serve outside jurisdiction. Now you see you're the person who's delaying the process. Yeah.
So, like in your practice, because you've been around and also you've noted that Rodol is able to be in various parts of the globe, which is interesting and also quite giving of your firm. I am curious because now I am moving this matter. Remember, we go back to the remote work we were talking about, and I've been able to forward it to the embassy. And remember, you have the fact that you've noted that they may not respond. They may actually ignore me as someone who will just be tired. What really delivers someone who's seeking out their justified goal from being worried by the system in trying to seek out on the other side?
No, that's an interesting question. But just to note, when somebody doesn't enter appearance within the period that is required by the law, after you have served.
And what timeline is that, kindly?
So if I filed a claim today against the foreign company, I'm supposed to be able to take out summons immediately. So once I take out the summons, I'm supposed to effect the service of those summons immediately. So once I have effected the summons, I've received the summons, and I've served them upon the foreign entity. So the moment you dispatch this particular summons at the Ministry of Foreign Affairs, you are considered to have effected service. So you do what is called a return of service. Return of service is something saying that I have actually served them with this document, and this is the proof that I have served them. You get? So if, for example, you are serving via poster, you attach the poster documents. If you served via email, you attach the email thread. If you have served via the Ministry of Foreign Affairs, that thing they have stamped received, you attach it there, right? So they have about 28 days. In an employment case like this one, they have 28 days to file a response. So if they don't file a response within 28 days, so your rights are not taken away. So what you simply do is you move the court to have the matter proceed as undefended.
Undefended meaning?
It has not been opposed.
Okay.
So the court proceeds with the case as undefended. And the court can still proceed to hear you and to even give you judgment without the respondent coming. And you can even still proceed to extract this judgment and go with it to the foreign country to execute it.
Before we go to the execution, let's take our second break.
Okay.
Right on Law Matters. We're taking it bit by bit because for a great margin, particularly with 67% of Kenyans being on the digital forefront, it's a matter that needs to be addressed, a matter that we need to be very careful about. So I'll let you there at home or wherever you are to take that in. As we come back, we're going to expand matters and also not only look at the employment bit. So for anyone who's doing those remote tasks, you know how to move about. And also in case it's too much, you can look for Akili right here. But apart from that, we're going to look on the business aspect because also the matters of creating jobs, particularly among the youth, call for us to think corporate while on an individual capacity. We'll be coming back on that in a moment. Don't go too far. This is Law Matters. And feel free to share your sentiments and comments on our social media platforms.
My name is Jakub Petri. I'm Associate Professor in the Institute of Philosophy of Jagiellonian University in Krakow, Poland. And I'm the main coordinator of the Cafe project, which is being here hosted by Kenyatta University.
My name is Ewa Hudoba. I am a project manager in this consortium. Keep watching cutting-edge research at Kenyatta University Television.
Miti miti, panda panda, miti miti. Our planet's future is in our hands. However, there is a threat to the brightness of this tomorrow. On EarthCheck, we share the challenges, the solutions, and the hope.
I would call this a very momentous day, a very critical day.
Every episode, every story, every step we take creates a ripple. Join me, the environmentalist Emmanuel Kutosi, on KUTV every Wednesday at 8 p.m. and be part of EarthCheck. Welcome.
You do when the justice you seek is across the border, and not just the border, maybe across the seas, even to places you have never set foot in. But believe it or not, there is an opportunity for you to get what's right by you and also by the law. And that is what we've been getting up to speed with Wakili Clifton Ouko, who has been breaking down to us that it is not a point for you to be worried or rather surrender on matters that concern you in matters of your rights in case they're actually beyond the jurisdiction of the country you are in. And Wakili, now we are into it. You are talking about matters of execution. But let's say I have looked at this matter and this journey will be quite heavy for us. One, I have to serve through the ministry. I've tried to follow up. I'm looking at the whole mathematics of one moving to come and also assess the assets you have, where they are, so that I can be able to get recourse. Talking on matters that are commercial completely. Yeah. I may decide now, let's have some arbitration. Let us now come to a mutual understanding. And from the basis of what I know about arbitration, it's more or less a win-win situation. If I am wrong, you will correct me. But I'm trying to get something that will balance out our dispute. Tell us about that and also help us to understand if I've put arbitration correct or not.
Okay, thank you for that. Arbitration is more of a court process, but it is balanced because now parties decide on how they want the arbitration to be conducted. You see, for the court process, you don't choose how you want the court to handle your case. You don't choose which judge is going to sit there. But for arbitration, you choose. Yeah, it is parties decide. It's called party autonomy. So it is a whole court process, if you think about it. So you will agree that in this case that we're dealing with, we are going to choose the laws of Uganda to apply. So parties are agreeing. You are choosing. That is number one. Number two, you're going to choose the seat of arbitration. The seat of arbitration could be Nairobi. It could be London. It could be Washington, D.C. So parties choose which one is convenient for you. And then they'll also choose who is the arbitrator. So we can, so the person who has declared, so what ordinarily happens is when you opt for arbitration, especially where there was an arbitration clause in your contract, so the party who is declaring dispute, so there's a party who will declare dispute via a letter to the other party. We have declared a dispute and therefore we are proceeding, we are invoking clause this of the contract which provides for arbitration. You get? And then that party will also propose that I propose person A, B, C, either of these three, or if you had said that you'll have three arbitrators, or if you said one, if you said one, the person will propose three names. So he'll give you three names of arbitrators who are listed in the list of the Chartered Institute of Arbitrators. And then the other person will say, okay, the list you have given me, I don't agree with any of those names. I propose other names. Or you can say, okay, I've agreed. Let's pick one name. But if you don't agree at all, it's a back and forth. So you will write to the chairman of the Chartered Institute of Arbitrators to appoint for you an arbitrator. Or you can even write to the Law Society of Kenya president to appoint for you an arbitrator. So then they will look at the list of arbitrators and then they will appoint one person to be an arbitrator. If the seat of arbitration potentially is in the UK, so you will write to the Chartered Institute of Arbitrators in the UK, because remember, Chartered Institute of Arbitrators is worldwide.
So this is a global body.
It's a global body.
Wonderful.
Yes. So they have an office here in Kenya. But just to take you back, so where you say that you want to have an out-of-court settlement, then arbitration will not be it. So what will be it is basically you can decide to appoint two parties from both sides to negotiate the issue out of court, so that what you do is you enter a settlement. But remember, even that settlement, you have to enforce it, because what will come out of that settlement or that out of court process is an agreement which will need to be enforced. So for instance, if it's a family dispute on inheritance, and then we were angling over a property in Tanzania and a property in South Africa. So we have agreed that let Eric take the property in Tanzania, let Lydia take the property in South Africa. Once we have that judgment from the court in Kenya, the family court in Kenya says now this property of the deceased person is going to be divided this way. The person who is being told to go and take the property in Tanzania may not use that judgment. The person who will still have to go to the court in Tanzania to find out what are the laws in Tanzania with regards to dealing with immovable property. Then the Lydia also has to go to South Africa to find out how do I deal with this property that is in South Africa, which is for the deceased person, but the family has agreed that I take it. How do I deal with it? So you remember that when you're talking about a dispute with a foreign element, it usually at times it's not just the dispute, because in this case that I'm giving you now, the family has agreed. Lydia take the property, they take the house in South Africa. Eric take the property that is in Arusha. But remember now, we will still have to go and introspect and check whether the laws of Tanzania require us to do certain things which the laws of Kenya does not want. You get? Yeah. So there is that settlement that we can do, but then we must also be aligned with the rules and the laws of each and every respective country. So where, for instance, you are angling over your payment from an employer who sits in Italy, for instance, you can be able to have a discussion on the settlement of the employment dispute, and they can decide to give you some very good amount of money in honorarium or something, you know. But remember, there are certain disputes which can't be addressed by out-of-court settlement, like an employment dispute, because the courts have said times and a number. If you unfairly terminated me from my employment, that is a separate issue from the amount of money you paid me because you fired me. You get? So you still have the legal channels to be able to. You can still have the legal recourse to yourself. And if you look at our Employment Act, for every unfair termination, the courts can award to the maximum of 12 months in salary, ranging from 0 shillings to 12 months of worth of your salary. So in that regard, you could have left. The employer gave you 5 million to tell you goodbye, yet you are earning 100,000. They give you, but you still say, you didn't follow the procedure to terminate my employment. So you go to the employment court. So just to say, for persons who are working for entities that are foreign, and you are residing in Kenya, so the laws of Kenya apply. So what does that mean? That means that the Italian company must be able to really deal with me within the employment context in Kenya. Yeah. So if they want to terminate my employment for instance, for poor performance, so we have to do a performance improvement. We have to do a performance appraisal. We have to do a performance improvement plan. We have to do a disciplinary process. Then now they have to get the place where they say, now you can't improve any further. You are fired. Yeah.
It's a lengthy process, and I'm pressed for time.
Yes.
In particular, I've tested the patience of my producer, but I'm still going to press more. You have our kill here. You're going to help me out when it comes to this. But I'm curious to bring it now to the matters of the business setup.
Yes.
Because we've talked about employment, and those who are employed have been able to catch something. And if they want, they would come back to that video and understand what is coming out. Now I'm looking in a situation where, let me give you a friend.
Yeah.
Let me give you Eunice. Eunice is this lady you are with in primary school, and she's watching Law Matters today, and she has seen, there's Clifton, that guy I used to study with. And Eunice has a situation. Eunice is making some software. Let's say it is for schools to be able to maybe manage their fees in a seamless manner.
Yeah.
She pitched it to this entity.
Yeah.
And the entity is not in Kenya.
Yeah.
And they requested, okay, let us see.
Yeah.
Send it, we review.
Yeah.
And they get it, it's good, they review. And the review is still reviewing.
Yeah.
They're still, so Eunice reaches a point and she's like, okay, according to the agreement I had made, by this time, now you guys should subscribe to this and let us make some finance move in either direction.
Yeah.
So Eunice sends an invoice and they're like, we are seeing, thank you for sending it, but this is still not to our standard. Yet they were using this thing. And here is Eunice wondering, now, Sasa, you're not going to see. And they're like, if you have an issue, kindly seek legal means. Like we are not going to, because it is below what we had agreed. Yet the agreement was very clear.
Okay.
These people are not within the
Kenya, and they have not
country.
signed an agreement.
They actually do have an agreement.
Okay.
But here is the situation. Eunice, your friend from primary school, went rapidly through this thing and signed and agreed so that the money can come in. It was a startup. It was her first sale, and she was very eager to make it happen. And here she is now, not compensated, put a lot of effort and investment into this product. It's a digital product. It's now in use in another territory.
Yeah.
And she cannot be able to get any recourse from it.
Yeah.
She has come to you for assistance. How do you help Eunice?
I think if Eunice listen to us today, she will get assistance because the first reason is this entity. You have to ask yourself whether they have a branch in Kenya or they don't. So if they have a branch in Kenya, then you can sue them in Kenya. If they don't have a branch in Kenya, then of course you have to just follow whatever the process that we have discussed here today to be able to sue them. And then now, because you're giving a scenario where there's an agreement, then you have to check what does the agreement say on on how to deal with that dispute. But just most importantly, assuming there's no agreement, because more often than not in such incidences, the service is usually offered, even if it's a system is usually unused, no agreement has been signed. Actually, one of the biggest issues that arises is there isn't any agreement. So what happens in that instance is you can sue the entity in Kenya because you are domiciled here in Kenya and you're doing business here in Kenya. And I was telling you about Rabobank, the Dutch company, which came from Dutch to come and file a claim here in Nairobi. So even you can sue. Of course, now you can be able to serve them through the communications you've had through email, and also if in case they have not responded, then you have to ensure that now there is that diplomatic channel of service, but you are able to pursue. So that's very critical, because commercial transactions are sensitive that way. They are risky that way. So you must also be ready to be litigious, especially when services are being rendered but payment is not being made and people are adamant not to pay. Yeah. So what is most important is how you get it. So, and this I tell many clients, it is important that you get it right when you start the transaction. So look at the agreement in totality and ensure that you are satisfied by legal counsel that this agreement I'm entering into is watertight. If there's a question about jurisdiction of which court can be able to have jurisdiction, you are confident, they are comfortable with it. If it's a question about the governing law, which law will apply, you are comfortable with it. Whether you want arbitration or whether you are saying that the courts in Kenya will have jurisdiction, you are comfortable with whatever it is that you choose in that clause, because you may think that, you may assume that the person you're entering the contract with is sane. I always tell clients, always assume every person you're entering a transaction with is not sane.
You're the only sane party in this one.
Yes.
And we are actually out of time.
Yes.
But I'm curious, in a final remark, perhaps you can tell us, and particularly I'm talking about the young people who are moving into the entrepreneurial side, and also on the digital aspect, because opportunities are there, but also there are pitfalls. Perhaps you can be able to, in a final submission, guide them on one, what to be on the lookout for, particularly when you're coming into these agreements, with the fact that we are moving to start up our own enterprises with so much figure. But this may actually be something that may crush a spirit that was moving to create that opportunity that may actually convert Kenya into a first world country. But someone's hopes have been dashed. What is that thing that, or those things that they should address to ensure, one, they actually move seamlessly even when they're going global?
So I think just one thing. So every transaction that we do, we must be able to take it seriously, because I think most young people, they always wait for the big deal to be serious. So even if you're selling a pen for, you're supplying pens for 10 shillings, one pen to different entities in Kenya, take that deal seriously. And I think what is most important to note is at the moment you start with a trend of ensuring that all your contracts for all the services that you're doing are ring-fenced, then you are moving towards the right direction. So that by the time you're getting a contract for 100 billion, you already know how to be able to put your house in order. Because the moment you are taking every deal unseriously, meaning that because you're desperate, the other person will be able to project the terms of the contract, and then you will oblige by them. Then once these issues that I've said, jurisdiction, governing law, arbitration, they are not in your favor, then what do you do? Because the countries which apply which apply these contracts differently. There are countries which are not common law, like Kenya is a common law country. So when you allow yourself to be in a contract, you sign it very fast because you are desperate to get the money, and the law, the governing law is French law. And you have not even you have even no idea of what French law says. You see, you are walking into murky waters. The moment this deal will go south, you might lose out on your hard-earned money. So it's very much important that every transaction that you enter into, you have to take it seriously and engage counsel. Because if you don't, also you might get yourself into muddy water. Yes,
and muddy water is not usually clean water. And the words are just three. Take it seriously. Those are the words coming out of our advocate from the High Court, Clifton, Ouko, and also associate at Rodel. And he has been able to bring it out to us. Unfortunately, we are pressed for time. But of course, Wakili Clifton is an amicus of the show. So in case you have any questions on the other side, of course, you can be able to share them actually on the live feed on YouTube or also on our social media handles at KUTV Kenya across all social media platforms and KUTV_Kenya on the X platform. And we'll be able to at least share back and also give you the insights, particularly noting that looking at such matters, they do touch on matters that come with the digital aspect, which is the space that most of us as young people are moving towards to be able to secure means to be able to earn a living in a unique way and also in a technological advanced age. This has been Law Matters, your legal aid clinic showcasing live on TV. My name is Emmanuel Kutosi, and of course, I'm very happy to be in court today and to be with one who is able to actually give me some knowledge, and I do hope you've taken something on the other side. To the team involved in the production of this broadcast, it's a big thank you and bravo. Thank you guys for keeping strong and ensuring that we are legally up to date. Till next time, keep it legal.
And just before you finish, my boss told me to give a shout out. Ile salamu za Waluya. Penina Munyaka, wherever she is, we give her a shout out.
This is Law Matters. Till next time.